First of all, thank you all for joining us today for this important discussion on the fears, doubts, and uncertainty on Saudi Arabia data privacy compliance. Let me introduce myself first. I am Amrita Kamalon, and I am the data privacy account manager who is helping organizations in KSA in achieving their privacy compliance. So recently, we've been hearing a lot of questions about the KSA PDPL compliance from our customers. So, what does the law talk about? What are the penalties for non-compliance? How should we start the privacy journey? Whose responsibility is it? And so on. So, we thought let's address all those questions in a webinar, and here we are. So, yeah, our expert speakers, Mr. Rahul Alavadi and Mr. Gaurav Arora, both are senior privacy consultants with strong legal and technical expertise. Through this session, they will guide you through the legal and technical aspects of implementing a successful data privacy program. With their experience working with multiple customers in GCC, they will share insights on how to manage personal data responsibility and stay ahead of the regulatory requirements. As for today's agenda, Rahul, can you please go to the next slide? Yeah, thank you. Our focus is around some of the common challenges and questions that we hear from our customers. So we'll discuss in detail about the KSA PDPL law, its applicability, practical tips on implementing a successful data privacy program. We will also discuss some of the case studies to understand some real life challenges and how we have helped address them. So yeah, all right, let's get started. We encourage you to engage with our speakers, ask as many questions as you want, and participate in this webinar. We promise you that we will answer every one of your questions. Yeah, over to you, Rahul and Gaurav.
With that, thank you so much, Amrita, for setting up the stage and welcoming the audience. Thank you all for joining. And so today, as Amrita mentioned in the agenda, that what we are going to talk about. So we'll start with a basic introduction about the KSA Personal Data Protection Law. Since I assume that many of you are very well versed, but possibly there could be a couple of people who would like to know in basic terms what KSA PDPL is. So KSA PDPL, the Saudi Arabia's personal data protection law, it is one of a kind Kingdom of Saudi Arabia's law, which is acting as a legal framework which is designed to protect how personal data shall be collected, processed, used, even stored, all the kind of data processing activities that is being done on personal data. For that, Kingdom of Saudi Arabia's government authorities, they have came up with a regulation that will put some kind of obligations, how personal data will be managed, what are the different kind of roles and responsibilities of the organization such as data controller and processor. So the main aim of KSA personal data protection law, it is to protect privacy of individuals and ensure that the organizations who collect and process personal data, they handle their data responsibly. Now this law was passed on 14 September 2023. So the organization, they were given a 1 year grace period so that so the organization could cater their culture, how they manage personal data and adhere to the regulatory requirements that are there. Now, to make sure that KSA personal data protection law is very well implemented within the organization, SADAYA, Saudi Artificial Intelligence Authority, this will be the regulatory body who will be enforcing this regulation. They will be creating the policies, procedures, they will be creating guidelines, even standard contractual clauses, so that they could act as an overseeing body or a regulatory body who could promote the personal data protection within the country. What is the current objective for this regulation? It is to protect personal data, and it is providing certain kind of rights to the data subjects so that they could reach out to the organization that these are the certain rights that we have, and it provides the ownership and power to the data subject how their data should be managed, and also sets certain kind of guidelines and obligation on the organization that how they should manage the personal data that they are processing. So with that, since we now understand what is KSA PDPL, a very big question that comes into the mind of people that does KSA PDPL apply to them or their organization or not? So we have a hand raised, yes, please.
Hey, you know what? The moment the webinar opened, we had two questions. I think it's just the right time to take those questions, right? One question is what kind of personal data are we talking about? Does it include employee data? That's the first question. Remember this question. Then the second question is any idea when the list of countries with adequacy decision will be published? So there are two questions. Just answer them quickly.
Okay, so perfect. So employee data, yes, it is a kind of personal data that is to be considered for the KSA personal data protection law. Now, the law personal data. Now, personal data could be of any individual. It could be your employee, it could be your customers, it could be your vendors, or any of the third parties of representative whose personal data is being collected. Now, this law will apply to all of those categories of personal data. So there is no segregation done by the law that this will only apply on the personal data of maybe customers only. So there is no such segregation. The law will apply to all kind of personal information that is being collected by the organization. Now, the list of countries for the adequacy decision, it is something that Sadaya has yet to introduce and provide that list. So this law is something that is new for the Kingdom of Saudi Arabia. They are building upon it. So as soon as it comes, please be active on our Helen Cyber's page. As soon as they come, we'll post the countries list of this for that adequacy decision. We are not yet, we don't know the timeline, but as soon as it comes, we'll share it with you guys. So coming back to the big question of the hour, does KSA PDPL apply to you or your organization? Now for that, we'll do a very small and simple exercise to understand if KSA personal data protection law applies to your organization or not. So the key term in the PDPL is personal data. So the first thing that we need to understand is, does our organization process personal data or not? Now, if that answer to the question is no, that we don't have personal data, then obviously KSA PDPL will not apply to that particular organization. But if the answer is yes, there are few more key things that we need to understand to identify if KSA PDPL apply to you or not. The first thing that we need to know when to understand if it applies or not is that where is the organization based in. If you are based in Saudi Arabia, then 100 and you process personal data, 100% KSA PDPL law will apply to you. But now if you are not based within Kingdom of Saudi Arabia, then what happens? So in that case, if you are processing personal data of people who reside in Kingdom of Saudi Arabia, or with whom you have intentions to do business services with people who are there in Saudi Arabia, and you process their personal information, no matter where your organization is based on, then also you have to follow the requirements of KSA PDPL. But if you are outside Saudi Arabia and you don't intend to give services and collect personal data of people in Saudi Arabia, then this law will not apply to you and your organization. So with that, we have a polling question coming up for all of you guys. I think this is something interesting that you all might be interested in. So the question is, what is the biggest challenge when it comes to implementing privacy law? So we have provided three options. One is lack of qualified professionals to take initiative for data privacy program, or being unable to convince the board and top decisions maker to invest in the data privacy to make our organization compatible, and being not sure which department should run the privacy program or make sure KSA PDPL is compliant. So we'll request our audience to please answer the poll that's popping up on the screen.
All right, all right. So Rahul, while we're waiting for people to answer the poll, there's one more question, right? The question is from a gentleman called Mr. Abdul. In the travel industry, we are required to collect passport information for processing flight booking. If we get the
Right.
passport of the traveler on email, is this allowed as PDPL? This is a good question.
See, receiving the data through email, it's good. Now the question comes at, do you follow all the required protection measures as per the required safeguards. Now you are receiving that passport. There are few things that you need to take care. Are you using it for only for the limited purpose? Are you keeping the copy of passport secure and don't giving it to somebody else? Is the data that you have is secure enough that you don't end up leaking that information or sharing the passport to any other people who is not authorized to see that kind of data? Those are some things that you need to see in those particular situations. So yes, that is allowed to receive because it's a business purpose, and in order to provide your services you need to collect, but there are certain things that you need to keep in mind when you deal with such kind of informations.
Got it.
So
Got
I
it.
hope that answers the question.
Yep. But one more question now immediately has followed. What do you mean by processing personal data? What if we are collecting employees' data and just keeping it? In the sense they're saying, I think the question says, I will take the data, I will not do anything with it. It's just going to be on my database. What is
Now,
that?
processing has a very wide definition as per the KSA Personal Data Protection Law. Even collection, if you are collecting the data, if you are using the data, if you are storing the data, if you are transferring the data, doing any kind of activity on any personal information will come under the picture processing. So it's a very wide term, not just very specific to like doing some kind of manual or automated activity, but even collecting, storing, managing everything come, even deletion is also considered as processing in terms of KSA personal data law when it comes to the terminology processing as we call, and we're going to use it multiple time in our slides as well. So do we have the poll results?
Oh God. Okay. Yeah, we do have the poll result. It's I think I won the bet with Amrita. I was saying that most of the people, most of the companies do feel that they do not have the qualified professionals to take initiative. I thought that would be the highest scoring answer, but I think yes, that's the highest scoring answer. So we've got answers to the poll. I think we should probably move on, Gaurav.
Also,
Rahul,
questions keeps coming in. We have one more question here. Does a SOC team monitoring log events also come under the purview of PDPL? If so, then how?
So it depends upon the logs and the data that is being collected in those logs that you are collecting. Let's say if you have the IP address in that log, you can identify that person, then it's personal data and you are processing personal data, so you need to be considerate. But if you have dynamic IPs in the log, you cannot identify that person, then SOC monitoring is out of purview of personal data protection law, because you cannot have or you cannot identify one individual person. So that's an example. So you need to see what are the different data elements that you are collecting and that you are processing. Identify with the help of which data you can identify one particular individual human being. If you have that data, then yes, PDPL will apply to you. If you don't have that data, PDPL will not apply to you. As simple as that. If you have personal data, you're going to come under the bracket. So with
Uh,
that, we'll pass on the
yeah.
stage to Gaurav to help you further with the presentation and share some more important tips and tricks.
Thank you, Rahul. And I'm aligned with the poll results as well, because this is something that we see across the industry and with our experience as well, that companies are facing a challenge with finding the right talent who has the right expertise in privacy. So that's interesting to know. Before moving into the next segment, thank you everyone for joining, and we are happy to have every one of you. And please feel free to drop your questions.
yeah.
Moving to the next segment, we'll
Just a moment, Gaurav. There are a lot of
yeah,
questions, so I think we'll park the questions to the end of the presentation, and we'll answer each and every one of them.
Yeah,
sure.
every question we will answer. There are some additional questions as well. So I'm making notes of all of them, and we can do that. Yeah.
Sure. So, starting with the key pressing question that every company sort of struggles with: why to focus on privacy in the first place? Why is privacy important, and why do they even need to focus on it? And the primary impulsive and instinctive answer is because it's a regulatory requirement. And that's the primary reason why every company is focused on privacy. And it also comes from a place that the consequences of non-compliance are exorbitant fines and also a lot of bad reputation. But that's a limiting view of focusing on privacy. Another angle, another layer towards why privacy is important is because of the trust factor. And that is what we see with our experience, that companies who look at privacy from the point that it helps in developing and building trust from their customers and different stakeholders, they have a better chance of optimizing towards privacy. And one of the biggest examples for this would be Apple. Apple itself, as an organization, is famous for the kind of privacy controls that they have in place. And that is something that they use as a marketing strategy or as a trust building factor, which helps them in building trust from the customers as well. But to start off with the journey of privacy, you always start from the place that it's a regulatory requirement. And what we see even from the IAPP reports is that because of these two reasons, 93% of the organizations have ranked privacy as their top 10 risks, and there's 36% of the organizations who put it as their top 5 risks. Another trend that we see across the industry, across multiple organizations, is that customers, when these laws actually come into force, it also empower and gives a lot of power to the users and customers in the form of data subject rights. And when they are educated and when they are actually aware of what they can do with their data, that's when they start taking actions. And that's what we see across different jurisdictions as well, be it Europe after GDPR was commenced, or even in US after CCPA came into force. So that's one of the reasons why privacy is important. And this is the reason why every organization needs to start focusing on privacy to start with. Moving to the next slide, here we'll address some of the key fears, doubts, and concerns that we see across different clients based on our experience. The first thing that we see is that organizations are concerned that the compliance deadline for SDIA is already passed. It was 14 September 2024. And it's true, that is something that every organization needs to take seriously. But the right approach towards this is acting as soon as possible, having a privacy program in place. And even SDIA as the regulator is going to focus on the fact that whether you have a dedicated timeline and whether you have a dedicated program in place that would show them the trajectory, that if even if you're not 100% compliant right now, within the next few months, how are you going to get there? So and that also takes us to the next point, where although the fines are exorbitant, 5 million Saudi riyal, the key point that comes into play when it comes to dealing with the regulator, which is the enforcement agency for KSA PDPL, is if the regulator is able to see that the organization has a dedicated plan, they have a program in place, and they have a journey that is how they're going to reach towards compliance, they are much more lenient and they're much more cooperative in that scenario. So the key takeaway from this point is that it is very important to have a program in place and have a strategy in place to actually move towards compliance, even if you're not there right now. The last point is on.
Sorry, Gaurav, that's an important slide there, because I get a lot of questions around the penalties. So hope this clears.
Exactly. And the last layer that we see is, do we need to set up a data privacy office to cater to data privacy requirements? And this is something that is and depends on the organization. There's a specific guideline on when the organization needs to have a specific dedicated data privacy office. But for most organization, the important key element is accountability. Even if you don't have an independent privacy office, it is important to make sure to identify who is going to be accountable for privacy, and that is what the regulator is also going to focus on.
There is
Rahul,
one
we can
question.
move to the next. Yeah.
There is one question which I would like to ask here, which is given by one of the attendees. Appointment of a DPO should be a dedicated resource, or is it possible to assign this responsibility to an existing resource? If it is assignable to an existing resource, which department is more suitable?
So firstly, having a dedicated data privacy officer depends on a few scenarios. For few industries and scenarios, it is important to have a data privacy officer. One would be if you're a public entity. The second would be if your core activity is based on processing sensitive personal data. But for rest of the scenarios, most likely it is optional. And if you're dedicating that responsibility to a third function, that depends largely on how your organization is structured. So it could either be with the compliance function, it could either be with the data team, it could either be with the security team, or it could either be with the legal team. So that particular situation depends largely on how the departments and how the teams are structured within your organization, and who would be able to take accountability for a program like this. Usually the right balance is that someone from a compliance team and someone from the technical side, be it from the security team, because for a concept like privacy, you need cross skills. You need something that has the legal and compliance understanding, and at the same time, you also need an edge of tech and security understanding. So this is subjective, and this is something that we can definitely help in identifying, but it is largely organization specific, and we need more information to have a dedicated organization specific response to this. So before understanding how to go about executing the privacy program, we would look at some of the key challenges that we've seen across the industry, across multiple clients. The first is that if you're a holding company, or if you're a conglomerate, or if you're MNC, you need to ideally have a unified privacy program. If you just start on complying with and having a program to comply with KSA PDPL, that is not the efficient way to go about it, and you likely be doing a lot of repetitive work, which is not the ideal scenario, and you would also face multiple challenges. So it is always important to take cognizance of the nature and structure of the organization as a whole, whether you're a group company, whether you're a holding company, whether you're a conglomerate, and that needs to be factored in when you're considering your privacy program. The second thing that we see is that it is also important to look at what your business is about and what is the scale of your operations. The way a privacy program would be implemented in a tech organization versus how it would be implemented in a service-based organization is going to be drastically different. So you need to look at the nature of stakeholders that you have, the extent of personal data that you have, and the scale of your organization as well. And that is something that is extremely important before you start on building your privacy program. The next layer is it is extremely important and helpful to leverage technology when you start with your privacy program, because for a lot of organizations, especially organizations that are data intensive, be it tech organization or consumer centric organizations, you would have a lot of data, and you would need a lot of resources if you're not relying on technology. And there are very helpful tools, be it OneTrust, Security, Big ID, that automate and make your entire process a lot more efficient when it comes to your privacy program. And that is where leveraging technology and having it when you are structuring your privacy program is very important. And the next and one of the most important part would be, even if you are using technology, you should never have the mindset that since we are using a tool, we don't really need to do much else. Technology is only a supporting tool to help you get towards compliance. You still need to have the specific KPIs that you need to achieve after the program ends or as the program moves forward. And then the next thing that you need to focus on is it is always going to be the policies, procedures, and processes that you have that would help you in actually operationalizing your program. And that's where using a combination of technology, processes, and KPIs is where you need to focus on when you're building your privacy program. Moving to the next part, some of the key strategies, and this is from a few mistakes that we see across multiple clients as we implement these programs across diverse industries, across different shapes and sizes of organization. The first thing is that privacy always needs to have the top-down approach. There needs to be a buy-in from the top C-level executives. Only then you would be able to have a successful privacy program. If you feel that only employees are implementing processes and policies that would be sufficient, it would never be sufficient. You need to make sure that privacy has a say in the board. It needs to be part of the larger and broader corporate governance strategy. And only then you'll be able to have a sustainable privacy program, because privacy is something that, particularly for the internal stakeholders, it's not something that they enjoy focusing on. It is an additional responsibility on their day-to-day operations. And that is why having the top-down approach, having the necessary privacy champions within each department, and when they see that the C-level executives are actually taking it seriously, that's when things actually start moving within your organization, which is one of the most important components of actually building a successful privacy program. The second layer is, it is always helpful that if you have a holistic view of data governance, because anyhow, for most organizations, you would already be tagging some of your data as confidential data, restricted data, based on different tiers as you interact with your different stakeholders. And you need to balance that and blend it with the tagging strategy for your data privacy program. Because if you consider your data, generic data hygiene and privacy separate, it would never work, because it is still data. Either it is non-personal data, either it is personal data. And that's why having a holistic view of the data that your organization process in general is very important. And last but not the least, a lot of organizations feel that privacy is a one-time thing. Once you implement it for the initial 6 months or 1 year, you're good to go, and you're set for the next steps. But that's far from the truth. Privacy is an evolving and continuously moving object. This is something that you would have to focus on as you move ahead. And even more importantly, from the technology standpoint, as we see how AI is evolving, there are multiple other technologies that are coming. And the way technology is moving at a similar pace, privacy is also moving forward. And that's why even the regulators and the regulations are also evolving accordingly. So it is always important to make sure that when you're building your privacy program, you have a foundational understanding that you need to make sure that the program is sustainable and something that you can take forward to the next stage. Rahul,
Gaurav, we
can
have a question
yeah.
from Mr. Vivek. For an organization which has not adopted any infosec or cybersecurity framework, no policy, no other documentation, and if they have to start complying with PDPL, how do they start? We would love to hear your thoughts on this one.
The first and the most important activity would be conducting a gap assessment exercise, which is something that we assist in as well, where you first on map what you need to do in order to reach compliance and what is something that you absolutely don't have. And that's when first you have identified the gaps, that these are the things that you need to focus on. And that's where you can actually move towards implementing those gaps. And what those gaps actually consist of is what we would be discussing in this slide. So if you're just starting with your privacy program, the first and the most important thing is having the gap assessment exercise. And the second, but I think this is one of the foundational pieces, or this is actually the edifice of your privacy program, which we are right now seeing on the screen as well, is data discovery and classification. Any activity that you're doing before doing this activity would not be as fruitful if you do this before starting your privacy program. If you don't know where you have personal data within your organization, you would never be able to reach towards compliance, and your efforts would not be as fruitful as they would be otherwise. Because personal data discovery and classification is the phase where we identify where data lies within your organization, which technical tools are processing which personal data, which departments are using which personal data, and then we also classify that data based on whether it's personal data, whether it's sensitive personal data. And that's where you get an understanding that, okay, marketing department is processing this personal data, HR department is processing this personal data, our application is processing this personal data. And that's where you can move towards actually implementing the right privacy controls that would help you to reach compliance. And in terms of what the other modules and components of the privacy program would look like, that's what we have on the screen. The second layer is the assessments. So once you have identified and classified the data, the next layer is conducting assessments on your specific applications, on your vendors, and also on your different processes, depending on if they meet a certain threshold. This is where we identify what are the risks that we have with the data and what are the controls that we can implement to minimize that data. Now, it could be scenarios where you implement role-based access controls, where you decide to encrypt certain data, where you decide to not process the data in the first place in a certain scenario, where you decide to use lockers, where you decide to use anonymization, and that's where the privacy controls come into place. But it starts from the point that you need to identify those risks in the first place. The third layer of a privacy program, which is also one of the key components of KSA PDPL, is data subject rights. This is where the users and the consumers and data subjects are empowered because the law has provided them with certain rights. These rights include rights such as right to access, where they can go to the organization and ask access to all of their data. They can go to the organization and ask the organization to delete all of that data. They can ask the organization to stop processing. They can ask the organization to withdraw their consent. And the reason this is very important, tricky at the same time is, if you don't know where you have data within the organization, you can never operationalize these data subject requests. And that is why conducting the discovery and classification exercise before actually moving towards the operationalizing DSR request, it is very important that you conduct the data discovery and classification exercise as a foundational piece of the program. And also, data subject rights is where you need to have a backend mechanism in place where different departments and different stakeholders would collaborate with each other to provide you with that data, through which you would actually share that data with the data subject, or you would actually go out and delete that data. So having the right infrastructure and integrations at the backend is what helps in operationalizing these DSR requests. The next is consent management. So a lot of organizations already collect consent for certain activities, and for certain activities, it is mandatory to actually process data only based on consent. One of those would be if you're doing direct marketing, for example, emails. Where consent management gets tricky is that not only you need to collect consent, but a user should be in a position that they can also withdraw their consent. And if they're withdrawing their consent, the organization needs to be in a position that they stop processing that data in that particular way, which again requires a backend process and a backend procedure to actually implement something. For organizations that are tech intensive, for example, if it's a banking organization or a telco organization, you might need to adopt certain tools, be it security, OneTrust, Big ID, and multiple other options in the market to actually operationalize these kind of modules. The next layer for the privacy program would be having a process in place to notify SADAYA, which is the regulatory authority, and the data subjects in case there is a data breach. So, as per the law, we need to respond to SADAYA within the first 72 hours if there's a data breach. And in certain scenarios where there's high risk towards the rights and freedoms of data subjects, we also need to notify the data subjects. And this again requires firstly identifying when there's a breach and then having a process in terms of how we go about in mitigating that breach, containing that breach. And this is again something that is done through processes and a lot of tools integration. The next activity for a privacy program is record of processing activities. And this is something that is made either at the process level or at the department level, depending on how your organization is structured. But the object behind this activity is to have a bird's eye view of how the data enters a particular process, how it is processed, for what reason it is processed, where is it stored, how long is it retained, is it transferred to any other department, is it transferred outside the kingdom, is it transferred to any other organization, and how it is deleted once the retention period expires. So this is more like a bird's eye view of what actually happens with a particular data element when it enters in your specific process. And with this, we also have a cross-border data transfer. In certain scenarios, when you're transferring data outside of kingdom, there are certain controls that you need to implement, be it standard contractual controls, be it binding corporate rules, depending on the nature and size of the transaction. These are the kind of privacy elements, privacy controls that need to be implemented. Hi Mukund, you have your hand
Gaurav, you
raised.
know so much about KSA PDPL that you'll probably talk about it till tomorrow morning. But buddy, we have some interesting case studies. I think see if you can speed it up a bit so that you can get to the case studies and you can maybe cover up some of these topics in the case study. That would be a good idea.
Sure. Moving quickly to the next element, this second last element is security for privacy. This is again something that is extremely important when it comes to your privacy program, because the only time privacy comes to the forefront is when there's a data breach, and data breaches are protected when you have the right security practices in place, and that's why security is as important as the privacy program in the first place. The last but not the least, we have the privacy notices, which are again a transparency obligation as per the regulation. We need multiple policies internally, and then there are also registration with this SDAIA. Looking over some of the practical tips when it comes to implementing privacy, one of the biggest challenge that we see with multiple of our clients is that we don't focus enough on the building a culture of privacy, and that's where it gets very tricky and very important, that if you don't focus on building a culture of privacy, if you don't focus on making sure that privacy is part of your day-to-day hygiene, it is something that would never be easy for the organization. So it is always important to have privacy champions with different departments, and something that they take seriously and something that they communicate and focus on their day-to-day operations. And that's where you actually move towards building a sustainable privacy program. Another key issue that we see is that organizations, which is one of the questions that we got in the webinar as well, is there's always confusion in who's responsible and accountable for privacy. Which department do we go to make sure that we are in compliant with the regulation? And this is where it gets very important to clarify accountability, that while building their privacy program, we focus on that this department, this individual is going to be the key point of contact, and going to be the specific person responsible for ensuring compliance with privacy, because there's always this tug of war between legal, compliance, security, data teams, who actually owns privacy. For organizations that are operating at a scale, it's easier because they can have an independent privacy function. But at medium scale organizations, it is very important to clarify accountability depending on how the organization and departments are structured, that who would be responsible for privacy. The second tip we have for practically implementing privacy is that making sure that the program is comprehensive when we are building it. So instead of picking bits and pieces that we just put a privacy policy on the website, or we just had one training within the organization, that is never sufficient, and it would always make you feel that you did something, but you would still be far away from reaching compliance. And that's where it gets very important that your program is comprehensive from the start. Another key tip that we see, which actually helps organization currently at this stage where the deadline to comply with SDIA is already passed, is to have a risk-based approach. You need to identify which risks are high risk, which risks are medium risk, and which risks are low risk. And only then you start on actually rectifying those risks, because considering that we've already passed the compliance deadline from SDIA, we need to be focused on prioritizing activities based on what is most important to focus on in the current state. Another key thing that we see is that, especially with larger organization, if you don't opt for a privacy tool, it gets next to impossible to reach compliance. If your organization is consumer centric and you have lots and lots of customers, particularly if it's a consumer centric organization, if it's a tech based organization, bank, telco, or any industry that is heavily interacting or providing a consumer based service, you would need a privacy tool at some point of time to identify data, to classify data, to operationalize DSR requests. And actually having this tool would also assist you in reaching compliance much faster. The last tip would be in terms of monitoring and adopting with the changing trends in privacy and with technology, because the way industry is structured and the way AI is evolving and the way tech is moving forward, over a period of time we would get to a state that by the time we reach compliance, there's something new from Sabaya that is coming. And that is why making sure that the program is sustainable and we have continuous monitoring within our privacy program is something that is extremely important. Rahul, we can
Just
move.
just a quick note. We are going to make sure that we are going to send you all the material without fail, so don't worry about it. Yeah, there are questions on what's the effective date of PDPL, that the deadline is already passed. So, so don't worry about making notes or taking screen grabs. We will send you all that you need. Yeah.
Next, we have a question on the screen, a poll question for you. And this is, have you identified all departments that own PI within your organization?
Personally identifiable information, right? And just give us
Yes,
some examples of what those are while people are answering the poll, please. That'll be important.
sure. Some of the very basic and very common PI would be name, contact number, addresses, if you're collecting some identification document. And these are PI elements that almost every organization is collecting at some level. And I think Rahul mentioned this earlier as well. Even if you're just collecting these details for your employees and you're a service-based organization, it would still be applicable for you, because employees and even your vendor representatives, they are also part of data subjects as per the KSA PDPL, and that's why it would be applicable to you in that scenario as well. Some lesser known PII would be IP addresses, because there's always this confusion that whether IP address is a PII or not. It is PII as per KSA PDPL, because the definition of personal data within KSA PDPL is quite broad. It says that anything that can directly identify an individual, and indirectly, even in conjunction with some other information, it would still be considered as personal data. So the threshold for considering whether some information is personal data or not is simply just if an information is specific or personal to an individual. In 99.9% of the scenarios, it would be PII. And that's what we need to focus on, because anything that is specific to an individual would be considered as PII.
And we are surprised to see there are so many people who have opted as no as the answer, that they have not identified the departments that own PII. Because, see, there could be possibly many departments like HR, finance, the sales department, the marketing department. Many of the departments within the organization, they do in their day-to-day operations work on personal data for their activities that they do. So it is very important to identify those kind of data and move forward for your personal data protection compliance. Now, to help you understand more, we have brought up some interesting case studies, a couple of case studies from the 30 plus projects that we have done, which will help you understand couple of challenges, couple of things. Yes, Mukund, so you raised your hand.
I just need this answer in 2 seconds. We've done about 26 implementations on PDPL, right?
Mhm.
Why have you picked the coming two case studies? If you can just give us an answer in 2 seconds, I mean 2 sentences, that'd be awesome.
So the main important reason why we picked these couple of case studies is because I expect it that the organizations or the people who have joined will find it very relatable. The problem that are solved, the challenge that was there, the solution that was provided, the impact that it's going to have is something that I purely believe that our participants will be heavily focusing upon, and it will be a benefit for them. So that's the reason we have these case studies. But before that, let's have some couple of real life insights that from different projects what we learned, and they could also become handy for the people who have joined today. So one very important thing, when we were doing our privacy by design and privacy by default assessments and for a cookie compliance project, we found that SDK, that's a software development kits which are there on the mobile applications, similar to cookies which are there for web applications. Android app collected more data than the iOS due to default SDK settings. Now, to ensure and enable the right settings for privacy by design and privacy by default, the organization who are developing some kind of product, they need to focus on what kind of default SDK settings that they are putting in, so that they could manage that balance of what personal data is being collected and what kind of privacy is being offered to their customers. The other is, but which is very, very common almost in each and every project. We have seen this happening across the Middle East market, is permanent storage of candidate data. It often happens, let's say, for example, there is one job opening within an organization, 100 candidates share their information to apply for that job role. You'll not end up needing that personal information of those 99 unselected candidates after an year or after 2 years. You'll not that need that information in any use case, and it will not be helpful for you. This law also provides and also provide obligations that the data that is not needed, please delete or discard that. You don't need to permanently store information which is not needed at all. It will cause risk which are uninvited, and you don't need that data, and still you are keeping it, and in case a breach happens, your reputation is something that gonna hamper. The other very important insight that we got from different projects is lack of awareness and training on social media usage of employees. We have seen it multiple times that people post pictures of their laptops, their screens, they'll create Snapchats and other different video recordings of their screen, which could compromise confidential and sensitive data without even the organization knowing that these kind of sensitive data leakage have happened. So we have seen cases where breaches have happened because people have leaked what kind of security controls are there on their computer screen. Because of that, the hackers were able to identify from the social media that, okay, this is the person that I need to target with. Or so we need to make sure that the people that we have within the organization, the insider information that we need to make sure that the people are aware within the organization that what are their roles,
Because
what
of
are their
that, the
responsibilities. Okay, so now we have an interesting case study that I assume is something that you guys must be interested in, wherein we had a automation project wherein a telecom company that was dealing with struggling with implementing privacy within their organization. The main challenge that they were facing is there were too many regulatory risks, and the organizations in telecom industry and various other industries like banking and all, they are heavily regulated by different kind of authorities. So they were also facing certain challenges in how to manage their compliance and show their evidences how they are fulfilling the requirements. And there were also many of blind spots which they were not be able to identify because of the manual approach that they were taking. So what solution we brought up from them is we implemented a comprehensive privacy management platform. With the help of that platform, they were be able to first identify their personal data that lies in their entire organization, even that is structured data or that is unstructured data. So with that, they were able to identify that data, and then they were it was made possible to enable data subject rights, which was very difficult for an industry that is like telecom industry. And they have plenty of vendors which they take services from, and we could be able to automate their vendor risk management and data mapping. We also help them to since they had more than 100 process in their business. So with help of our solution, we were able to automate their privacy impact assessment. So all the reminders, all the evidences, all the answers, they were located at a one single platform, and they were able to do it very effectively. And importantly, they were able to do it and complete it and make sure that all the risks that were identified from this privacy impact assessments, how they have to be treated so that they could run their privacy program in a most suitable manner. What was also as a part of solution is to implement a cookie and consent management solution, wherein they were also collecting cookies from their multiple websites and multiple applications. So that also helped them to create a record of consent, which is certainly considered as a pain point for a lot of organization that if they consider consent as their lawful basis, they don't know how to collect consent. They don't know what will be a clear and valid consent, and they do are not able to provide the proof that the consent was collected. So with the help of this comprehensive privacy management platform, we were able to satisfy that requirement as well. So it brought a huge impact on the organization. Now, in the terms of business as well, since that organization was able to commit to its customers that we are privacy compliant, people were more inclined to use their services in terms of their competitors. So that was also a very big impact that came since they were able to demonstrate that they are privacy compliant. It also enhanced their regulatory posture, which saved them from multiple fines that could come from Sadaya or any other different regulatory authority. Also, it streamlined their process, that how they do and how they manage that personal information. So multiple benefits were availed by this customer as part of the privacy program that was built for them. So that was our first case study, and the second case study which we are going to talk about is very common scenario across the Kingdom of Saudi Arabia market, which we have seen in multiple cases, that there is a group holding company and there are multiple subsidiaries that work under that. There are different company registration, but they treat that organization as one, which is not truly the case as per the lawful structure of that organization. So for various kind of operations, various kind of businesses, these entities, they shared personal data across each other without even knowing that there are some things that or some obligation that they need to take care. And there were inconsistent holding structure and relationship that how the personal data sharing should be managed. So what we helped them with by our consulting services were we shared them and created some service agreements, intercompany agreements, that how to enforce a legal framework and a lawful basis, that how and when can personal data be shared among these internal entities who are part of that group holding company. Also, what we did is we created the standard contractual clauses, all the required legal documents as well, and enhanced how the data principle of sharing and minimizing can be implemented so that personal data flow can really happen. And instead of just bouncing back to each and other department, then how, what can we share, what can we not share, a clear, consistent framework was created so that the business operations could move in such a manner that all the activities could be completed on time, as well as all the activities they could bring out a yield and should be at parallel times lawful as well. So the impact was to be able to create an internal data sharing practices, internal company agreements, how data is to be shared, and ensure at each point of time, even if that company or the subsidiary that they have as their holding entity, even if that entity is based outside Kingdom of Saudi Arabia, still they are required to follow the requirements of KSA PDPL. So those kind of requirements were also addressed to help the organization in flourishing their businesses. Yes, Mukund.
Rahul, look at the clock. We just open the two polling questions and then we'll move on.
Perfect, perfect. We'll just open it up. Just a quick update on the services that we provide. One is gap assessment, wherein we assist you in conducting the gap assessment to identify what are the things that you need to do, what are you currently doing, and finding out the gaps so that we can create a roadmap for you that how and what are the things that are to be done or to be implemented. Towards the second thing, we move towards the advisory and consulting phase, wherein we assist the organization in creating those policies, procedures, documents, and each and every required document that is there to make sure the organization comply with personal data protection requirements. The next is the implementation services, where most of the organization they do struggle that how is privacy to be implemented, what are the different tools and technologies they can use. So that is what where we bring the value to automate those activities, to train them, to let them know and implement the thing in their entire system, that these are the things, these are the way how things have to run. With that, we move towards continuous monitoring, wherein will enable you how you can sustain your program for your entirety till the organization exists. So to how to monitor the privacy governance program, how to continuously assess any new risk, and how the organization employs and the resources they manage the personal data. With next line item as the data privacy audit, wherein we support the entities to conduct personal data protection audits for even if there is any third party vendor that they are looking to onboard, we need to audit that. That is also where we support them, and even conducting the internal audits to make sure they are all set and ready to face any audits from Sadaya. So that is what we as Ellen Cyber we bring to the table. The next poll question we have is, have you done any sort of privacy assessment or not? So we'll have that poll question, and to in case even if the answer to you is no or not keen on it, you still have a very good opportunity that is there for you free of cost, and you can go to our website where you can take our online privacy assessment test, so you can understand what is applicable to you, what are the different obligation that comes on to you, various things that will help. This test will help you provide answers to so to tell you why Ellen Cyber, why to trust us with your privacy compliance program. We have more than 30 plus clients who will answer that with a smile that they have a well mature privacy program within their system, and we provide the end to end privacy services wherein from the start to the end related to any of the activities, since the services that I showed you in the past slide, it also enables the organization from start to end to make sure all the services that is required in a privacy compliance you can get it at a one stop solution. We also have a very rich pool of privacy experts with the right techno legal people who can provide you the process optimization services, the legal services, wherein what are the documents, standard contractual clauses that are required. Those kind of things are something that could be provided. So with
Mukund, sorry, Mukund, can
Yeah,
you please,
go ahead, Amrita, please, go ahead.
could you please share the link for that privacy assessment test on the chat?
Oh, yes, yes, I will share the link for the privacy assessment on the chat, and we will reach out to most of you. So the link will be there. So we will send you an email that has all of that. This has our email IDs, and if you want to talk to us over phone. Uh, what we will do, we will take up the questions now. And I know we are at the end of the hour, but we are going to answer all the questions. We are also going to reply to some of these questions over email. But thanks so much for those who have other meetings. We will continue. We will continue answering the questions. But in case you have another meeting or you have another call to attend to or whatever it is, uh, please do carry on. Thank you again for coming to the show. But now, Rahul and Gaurav, please let's take in all the questions and answer them to the best of our capabilities.
So it's
There's
time to
been
keep the
request
promise
for
that we had.
summarizing the
Yeah.
webinar. We will be sending you the recording and we will also send you a small summary of that. Thanks.
Yeah. Mukund, there is a question from Mr. Imtiaz, so I think we'll address that first as he has to attend another meeting in 5 minutes. So, Rahul, here is the question. I'm a little bit confused as PDPL is mixing or overlapping with NDMO. Is date same for both or NDMO has different date for P1? I'm sure
So
that you have received this question a couple of times before.
yeah.
So, yeah.
So, see, the domain 14 of NDMO is very similar to what are the requirements in the KSA PDPL. But difference between NDMO and KSA PDPL is the first thing that we need to understand is the applicability. So, the applicability and the requirements for the NDMO is more towards the public entity that are there or the entities who aim to provide services to the government entities. So that is one, it is mandatory for all of those organizations to fulfill the NDMO requirement. The second thing is that NDMO's policies, they are towards the entire data management framework. There are 15 domains in the NDMO, and out of those 15, one domain is personal data protection. So KSA PDPL is a law for the entire country. NDMO are certain guidelines for certain set of organizations. So the dates and the management is different as part of the compliance requirement comes up. So you need to first understand, does your organization need to do the NDMO requirements, need to meet them? If yes, then you have to understand that there are definitely a syncing between both the two. And when you create your personal data protection program, you have to consider the delta if there is any in both of these regulatory obligations.
Hopes that answer your question, Mr. Imtiaz. So, moving on to the next. Um uh, Mr. Gaurav, we can take this up. We have BCR signed between our affiliate companies despite the guideline given by Sadaya on BCR. How can we assess if our actual BCR fulfill the requirements?
That is something that we would need to look at with what the BCR entails, uh, because actually implementing BCR as per the KSA guidelines would depend on if the BCR in itself is compliant with the requirements. On top of it, there might be certain scenarios where you can just do with standard contractual clauses. And on top of that, we would also have to look at if the organizations or the entities, affiliates in itself are structured to be in a position to comply with the BCR. So that is something where we would need to have a more information in order to actually have a response to this if the BCR is in compliance with the regulation.
Thank you, Gaurav. Rahul, maybe you can answer this question. Is it necessary to have DPO within the company if company is small and stores only employee data?
So the answer is it depends. Now, given the things that you have already mentioned, that it's small company and it is only employee data, then it is completely optional for such kind of organization to have a DPO or not. It is totally depending upon the organization situation and the requirements. If they feel the need, they can have a DPO, but it is not a negotiable thing that they don't give a person the responsibilities that a DPO takes care of. So they need to have that accountability, they need to have that framework. Having a dedicated data privacy officer is definitely not mandatory as per the information that was provided by the person, but the organization which are big in size, who deal with personal data as their primary source of business, where they are largely working on, or they are public organization, they mandatorily need to have a data privacy officer. Where in small organization, they have that feasibility or flexibility to choose if they want to have a DP or not, but the obligations will still be on them. They have to comply with the requirements that are there for the KSA PDPL.
Thank you, Rahul. Another question for you, Gaurav. Scope of PDPL is applicable only to external data only or to internal employee data as well?
It is 100% applicable to internal data as well. Any piece of personal data that is processed by the organization, whether that is internal employees, whether that is external customers' data, whether you're just collecting some data of job applicants, they're not even your employees, they're not your customers, but they're just applicants who applied for job. Even for those, KSA PDPL applies. Even you have vendors that are organization, but if you have, let's just say, a name and email address of a vendor representative, even in that scenario, the law would apply. So the applicability of the law depends on the nature of data, not on the data subject category, whether it belongs to customer employees. As long as the data is personal data in nature, it falls within the ambit of the law.
And this PDPL document, can public have access to that? Is it a public document?
Yes, it
Yeah,
is.
yeah, it's a public document.
That was another question. Yeah.
If you want to have a look, you have implementation regulations, you have the law copy that's published over the Sadaya website. Just Google it and you'll find it.
Maybe we can share the link here on the chat.
Sure.
And another question for you, Rahul. Can you give some examples of sensitive and non-sensitive personal data?
Okay, so this categorization of
There's
sensitive and
another
non-sensitive.
interesting question as well.
So, continuing to the answer, so there is to identify if a data is sensitive personal data or non-sensitive personal data, the important question that you need to understand is, does that data associates with a significant harm if that kind of personal information is leaked? So any information like health information or information that is relating to race or ethnicity, that could cause discrimination in case some people might get hold of that information, my political opinion and beliefs. So multiple kind of information, if that is causing significant harm, if that is leaked, that is to be considered a sensitive personal information. Now we have a definition that is published by Sadaya, what constitutes with the certain examples like health information will be also coming under sensitive personal information, or credit data will also be considered like that. So these kind of definitions, it's they are there, but to in simple words, if you want to identify, just think of the risk that is associated with that kind of personal information. Like my name would not be that kind of a thing that if my name is leaked to someone and they will, it will cause a significant harm to me. The answer is no. So that is a non sensitive personal data. But my health information, if that gets leaked, then I will be concerned that somebody is knowing about things which I don't want to, then I will call it as a sensitive personal data. So that's a basic difference, and definitely we have the definitions from the Sadaya, but to answer in a simpler manner.
Another question. Our organization is diplomatic like World Bank. Is privacy law applicable as our legal is unsure about it? Rahul
Yes.
or
So,
Gaurav can take it
yeah,
up.
the applicability of PDPL in that scenario would depend primarily on the fact if you are processing data of KSA residents. if you have any employees who are based in KSA, the law is applicable to you. If even from the banking perspective, you are processing any data of KSA residents, the law would be applicable to you. So the threshold depends on the fact if the processing activities that you have within your organization includes any processing related to KSA residents. In any of those scenarios, the law would apply to your organization.
Thank you, Gaurav. Mukund, did I miss any other question?
Nope, I think you did not. But what we will do to all the people who are still on the call and all the people who answered those asked questions, we will definitely reply back to all of them. And we will probably even do a question answer compendium and email it to many of our clients. Right. So that we will definitely take care. I think it's been a fantastic session. Thank you so much for all the people who have been with us. Can you just go back to the content, the previous two slides where we had our email ID and our phone number? Thanks everybody. Our email IDs and our phone number is here. You can contact us if you need a free privacy assessment or if you had any other further questions. Gaurav, Rahul, Amrita, we are always happy to answer those questions to our best of abilities. You've been a fantastic audience. Thank you again for coming to this webinar.
Thank you all. Thank you for
I
joining.
request all the
Thank
people
you,
who are
everyone.
and the speakers to just stay on.
Sure.